Hi, this is Mike DelSignore. I want to talk about what happens if you're charged with OUI in Massachusetts and the case is going to be heard in the Palmer District Court. So I want to tell you a few things about an OUI arrest. An OUI arrest is a crime of opinion. It's sort of a unique criminal offense because most crimes, the police are saying they saw something happen. They said, all right, we know there's a victim here. There's a domestic. We know this building was broken in. But an OUI is unique because they're saying, well, we think you were under the influence of alcohol. They don't know that for sure. It's just the officer's opinion. Even if there's a breath test evidence, that's an estimate of your blood alcohol. There's reasons why those are inaccurate, unreliable. There's different procedures officers should follow. So it's really a crime of opinion, no matter whether it's a breath test or a blood test. Blood tests are, again, a blood test at a hospital. That's an enzymatic test. It's not a blood test. It's a test of a reaction between enzymes. They're not testing your blood directly. So keep in mind, these are subjective cases. For example, the police are going to say that you drove erratically, unsafely. There might have been a marked lane violation. But that doesn't mean you're under the influence of alcohol. The way they get to the conclusion that you're under the influence is they're trying to say that these field sobriety tests you did on the side of the road are somehow reliable indicators of whether you had too much to drink. So the fact that you couldn't balance on one leg, they're saying that means you're impaired. But what other causes could there be of somebody not being able to balance on one leg? You could have a bad knee, bad back. You might have been tired from work. You may not be that athletic. You might not be in the best physical condition. So there's all these other causes that explain their observations that are other than alcohol. 9-step walk and turn, they might say you missed heel to toe, didn't turn correctly. But you were given basically about 8 or 9 instructions in a 40-second period and asked to remember them all. And so many people, the nervous, never been in this situation before, aren't going to really remember everything that's being said in the specific detail the officers are going to require for these field tests. When I look at most reports, I'll say you did well. In other words, just because you didn't maintain perfect heel to toe doesn't mean you failed that exercise. What we try to do is show that you substantially perform what the officer had. You maybe didn't do it as perfectly as they wanted to, but it's your first time doing it. You did the best you can under these conditions, so that your performance doesn't show impairment, but shows maybe somebody unfamiliar with the test. Maybe it shows that you don't have great balance, but not that you're under the influence of alcohol. So key things to understand: when you're charged with an OUI offense in Palmer or any other court, keep in mind you can do these cases in front of a judge or a jury. I would say about half the cases I think you can do in front of judges. I think judges are very good on OUIs. They understand that these are subjective. They understand the standard of proof is very high, beyond a reasonable doubt, and I've done many in Palmer District Court specifically. If there's a breath test, keep in mind that this doesn't mean it's going to come into evidence. Just because you took it, just because it's listed on the police report, doesn't mean that that's going to be heard in court. You still can fight that. You can still challenge whether the officer complied with all the rules and regulations, whether you consented, whether they complied with the 15-minute observation period, and whether the machine's accurate and reliable. There's a lot of new information about this machine, data that really hasn't been discovered before, that we can use to challenge the reliability of the machine. If you refuse a breath test, your license is initially suspended for 6 months, but there is an appeal process to that. So keep in mind that there's an appeal process. If you're found not guilty, you can get your license back prior to 6 months. So the 6-month suspension, it's not 6 months, no questions asked. There's 2 ways around that: either not guilty verdict or appealing the refusal suspension. So, and if you definitely need to get on the road and none of those are viable alternatives, meaning it's a difficult case, if you resolve the case within the 6 months, you'd be eligible for a hardship license. So there are different scenarios, different ways you can handle the case depending on your situation. And that's what's important. When I represent somebody, I always talk to them, find out what's going on in their life, what their job, family situation is like, so we can make the best decision for you for your case. Now, for many people, it's to fight the case, take it to trial, because there's very little downside to losing these cases. Generally, the disposition after trial, meaning what the judge would give you if you lost, is pretty much the same as if you took a plea. So there's not a huge incentive to take a plea, but everyone's situation is different. I'll talk about your situation, go over it with you, and come up with the best plan for your case. You can call me, text me anytime, my cell, 781-686-5924. It's never too early or too late to call. My name is Michael DelSignore, here to help you with your OUI charge in Palmer District Court. Feel free to contact me weekends, holidays, nights, anytime, and I'll gladly answer your questions.